May it please the Court. My name is Grainne Conway, and I, along with my co-counsel, Mr. Raymond Heneghan, and Ms. Amanda Wolfe, will be acting on behalf of the appellant in this case, Mr. George Greene. Would the Court like to be reminded of the facts of this case?
No, I'm familiar with the facts. Thank you, Ms.
Thank you, Judge. We will be arguing 4 issues in this case. I will be rebutting the presumption of constitutionality. My learned co-counsel, Mr. Heneghan, will be submitting arguments for the breach of the constitutional right of Mr. Greene's privacy and the breach of the constitutional guarantee of equality. My learned co-counsel, Ms. Wolfe, will be submitting that the Oireachtas fails to proportionally balance the competing constitutional rights in this case. It is respectfully submitted that Section 7A of the Criminal Law Sexual Offences Acts 1993-2017, as seen hereinafter at tab 1 under the legislation subheading of the Book of Authorities, enjoys a presumption of constitutionality. However, Judge, this presumption is not absolute and can be rebutted. May I open the case of Pigs Marketing Board and Donnelly?
Thanks very much, yes.
Would the Court like to be reminded of the facts?
Oh, that's grand. I know the facts. Yeah.
Thank you, Judge. Would the Court... In tab 21 of the Book of Authorities, page 417 of this case, the Honourable Mr. Justice Hannah held, when the Court has to consider the constitutionality of a law, it must, in the first place, be accepted as an axiom of the law passed by the Oireachtas, the elected representatives of the people, is presumed to be constitutional unless and until the contrary is clearly established. We intend to clearly establish this contrary in the subsequent arguments. May I open the case of Toohey and Courtney?
Yes, certainly.
Would the Court like to be reminded of the facts?
No, that's fine.
Thank you, Judge. In the Book of Authorities, tab 30, on page 34, the Honourable Mr. Justice Lynch of the High Court concluded, the onus is on the plaintiff to prove in a compelling manner that the impugned provisions of the Act are unconstitutional if he is to succeed in having them declared invalid as repugnant to the Constitution pursuant to Article 15.4 and Article 34.3, subsection 2. May I open the case of Article 26 of the Constitution and the Offences Against the State Amendment Bill?
Yes, certainly.
Would the Court like to be reminded of the facts?
You can just outline the how it came to the Supreme Court very well.
In this case, the bill conferring a power on a minister in order detention of a person is of the opinion that a person was engaged in activities which, in this opinion, are prejudicial to the preservation of public peace and order of the security of the state. The constitutionality of the bill was upheld, but when giving judgment for the court, Chief Justice O'Sullivan announced that it was the judgment of a majority of judges, implying that there had not been a consensus. This case can be found at tab 11 of the Book of Authorities. At page 478, the Honourable Chief Justice O'Sullivan held, where any particular law is not expressly prohibited, and it is sought to establish that it is repugnant to the Constitution by reason of some implied prohibition or repugnancy, we are of the opinion, as a matter of construction, that such repugnancy must be clearly established. It is respectfully submitted that this provision can be rebutted as it is clearly repugnant to the Constitution. This can be seen in the case of our client, Mr. Greene. There has been an evident breach to his right to privacy, which is constitutionally protected. A private matter between 2 consensual adults should not be an issue that the courts intervene with. Mr. Greene's constitutional guarantee to equality has also been breached, as he is the only one being punished in an act that was undertaken by 2 people consensually. The breaches of right to privacy and the equality guarantee will further be elaborated in the subsequent arguments. If I can be of no further assistance, Judge, I will thank you for your time and pass you on to my co-counsel, Mr. Heneghan.
Very well, thank you very much, Ms. Conway.
May it please the Court, I will be putting forward the submissions on behalf of Mr. Greene, which deals with firstly the right to privacy and secondly the right to equality before the law. It is respectfully submitted that Mr. Greene's constitutional right to privacy has been breached under Article 43, subsection 1, which reads, the State guarantees in its laws to respect and as far as practicable by its laws to defend and vindicate the personal rights of the citizens. May I open the Irish Supreme Court case of McGee and the Attorney General, which was decided in 1974 and is located at tab 15 in the Book of Authority. Would the Court like to be reminded of the facts?
No, well familiar, thank you.
Thank you, Judge. The right to privacy is an unenumerated fundamental right which was initially recognised in the case of McGee, where it was held that Mrs. McGee's private marital affairs demanded the utmost privacy. The Honourable Mr. Justice Walsh at page 312 held the sexual life of a husband and wife is of a necessity and by its nature an area of particular privacy. Thus, in applying Mr. Walsh's judgment to Mr. Greene's case, it must be put forward that the sexual activity between 2 consenting adults should ultimately remain a private matter without any state interference. It is respectfully submitted that the restriction of the right to privacy may only arise on a valid breach of public policy. May open the Irish High Court case of Kennedy in Ireland that was decided in 1984 and is located at tab 12 in the Book of Authority. Would the Court like to be reminded of the facts?
No, I'm familiar with the facts, thanks.
Honourable Justice Mr Hamilton held that the nature of the right to privacy must be as such to ensure the dignity and freedom of an individual in the type of society envisaged by the Constitution. It is therefore submitted that Section 7A of the Act, which criminalises Mr Greene, is a breach of his right to privacy, and in accordance with Article 40 of the Constitution. There are subsequent measures which have already been put in place to protect those working in this industry, and the invasion of privacy by the state in Mr Greene's private affairs is not what is ultimately envisaged by the Constitution. May I open the Irish Supreme Court case of Norris and the Attorney General, which was decided in 1984 and is located at tab 19 in the Book of Authority. Would the Court like to be reminded of the facts?
Well known.
Thank you, Judge. It is submitted that the right to privacy was recognised by the minority, which is now the more favoured approach today. In this case, it witnessed Mr Norris take a challenge for the invasion of privacy by Section 61 and 62 of the Offences Against the Person Act 1861, which made it a criminal offence for two consenting males to carry out a sexual act in private. The learned Mr Justice Henshey of the Supreme Court held at page 72 that a right to privacy inheres in each citizen by virtue of his human personality for purposes not always necessary, moral or comprehensible. It is submitted that Section 7A of the Act was an invasion of Mr Greene's privacy when he engaged in a sexual activity with Miss Wilberforce. The Honourable Mr Justice McCarthy of the Supreme Court further held in Norris at page 102 that in my opinion a very great burden lies upon those who would question personal rights in order to justify state interference of a most grievous kind, the policeman of the bedroom. Your Honour, as a diverse nation that we are now becoming, surely we're gone past this ideology and notion that there is a policeman hanging over people whilst in the bedroom, particularly between two consenting adults. I will now put forward the submissions on the right to equality.
Before you do that, Mr.
Yes,
Heneghan, might I ask, you have quoted Hinchy J in McGee on the particular extract that the sexual life of a husband and wife is of necessity and by its nature an area of particular privacy. And when one reads that, obviously, and I suppose the same could be said for an unmarried couple of either sex, heterosexual or homosexual or lesbian or whatever, that the sexual life of all those individuals are by its nature matters of particular privacy. And you're relying on that to equate it effectively with what transpired between Mr Greene and Miss Wilberforce.
Yes, essentially, as
yes, but the quotation you rely on would suggest that Hinchy J had in mind the I suppose what one would call an ongoing relationship, and which obviously doesn't arise. And even if you were to argue, Mr Heneghan, that on the next Galway races that Miss Wilberforce Smith came over, that wouldn't equate, and I'm playing devil's advocate now, with the type of relationship, if you like, or that the parties had in McGee, or indeed any couple had, married or not, or of whatever sex.
well, the use of that quote, Judge, is basically it highlights the fact that without the McGee case, there wouldn't have initially been this recognised right by the courts to the notion of privacy, either be it marital or not marital.
I see. Thanks very much.
I will now put forward the submissions on the right to equality on behalf of Mr Greene. It is respectfully submitted that there has been a clear and unequivocal breach of Mr Greene's right to equality, which has been set out in the Constitution through most notably Article 41, which states all citizens shall, as human persons, be held equal before the law. May I open the Irish Supreme Court case of MD and Minor in Ireland, which was decided in 2012 and that is located at tab 16 in the Book of Authority. Would the Court like to be reminded of the facts?
Briefly, yes, thank you.
In the case of MG minor in Ireland, at the age of 15, the defendant engaged in sexual activity with a 14-year-old girl. Although there was consent, it was subsequently held, and he was convicted under Section 3.1 of the Criminal Law Sexual Offences Act. He took a challenge as to the invasion of privacy when there is, although they are underage, that there was consent between the two parties. In this case, the Honourable Mrs. Chief Justice Denham made reference to this right, where she stated that the principle of equal treatment, page 38, as an implicit in the free and democratic nature of the state, it primates the Constitution. Chief Justice Denham at page 38 goes on to further state that the right to equality is one of the highest and noblest aspirations that modern day states aim to have within their constitution. It is respectfully submitted that if Section 7A of the Act is applied, Mr. Greene, as being the male buyer in this situation, will ultimately be discriminated against whilst engaging with a woman of this profession, which arguably is a female-dominated profession. It is respectfully submitted that this is a breach of Article 41 of the Irish Constitution. It is respectfully submitted that a discrimination of treatment stems from the decriminalisation of prostitution and subsequent enactment of the impugned provision, which will lead to an inequality of the purchaser of sex at all times, regardless of the situation. Therefore, we ask the Court to find that there has been a breach of Mr. Greene's fundamental rights of privacy and equality. If I may be of no further assistance to the Court, I will now hand you over to my co-counsel, Ms. Wolfe.
May it please the Court, I will be submitting that the Honourable Mr. Justice McGlynn of the High Court erred in applying the reasonableness standard with that of a proportional standard when reviewing whether the Oireachtas has breached a valid balance of competing constitutional rights. May I open the Irish High Court case of Heaney in Ireland?
Yes.
Would the Court like to be reminded of the
Fine,
fact?
you can open the...
Thank you. In the Book of Authorities, tab 10, page 607, the Honourable President Costello established the widely recognised test of proportionality. The learned judge held that the objective of an impugned provision must relate to concerns that are of pressing and substantial importance to override constitutional rights. The provisions must be rationally connected to the objective and not be arbitrary, unfair, or based on irrational considerations. The provision must impair rights as little as possible and be such that their effects on rights are proportional to the objective. We respectfully submit that Section 7A of the Acts does not pass this proportionality test. The objective of Section 7A of the Acts, which was established through countless Oireachtas debates, is to stop prostitution with the overarching policy to eradicate sex trafficking. Judge, we submit that if the impugned provision were to satisfy the objective, there would be no discrimination between the purchasers and the prostitutes. We respectfully submit that this is unfair of the provision to restrict our clients' rights, constitutional rights, when the Oireachtas does not legislate to restrict the prostitutes' constitutional rights. If acts of prostitution were of substantial and pressing concern for the state to limit, we submit that the discrimination between the purchasers and the prostitutes would have to end. We submit further, as you'll be aware, that the eradication of sex trafficking is not a pressing issue, as the purchasing of sexual services from a trafficked person was already illegal under Section 5.2 of the Criminal Law Human Trafficking Act 2008, before the enactment of the amendment to the 1993 Act. This legislation can be found on Legislation Tab 2 of the Book of Authorities. We submit that the right to privacy is not absolute, as has been discussed by my co-counsel, Mr. Heneghan. He importantly submitted that the right to privacy cannot be restricted by the state in the name of the common good. It is irrational to limit the right to privacy because the state does not like what consenting parties are doing in private. We respectfully submit that the impugned provision is unconstitutional, as it disproportionately breaches our clients' constitutionally protected rights to privacy and equality. This appeal should be allowed. If we can be of no further assistance to the Court, this concludes our arguments on behalf of the appellant.
And just one question. You say in your written and indeed oral submissions that McGlynn J. erred in applying effectively a reasonableness standard as opposed to the proportionality standard. But I'm looking at the extract from his written judgment in the matter of Greene and the Ireland and the Attorney General, and he talks about that the court should not intervene unless convinced that individual rights have been restricted to an unreasonable and disproportionate extent. To what extent do you say that he doesn't, while you say that, would you accept that it's not the case that he doesn't not apply a proportionality test? Because I'm quoting here, it says, it seems like a proportionate response to a difficult and social problem.
We submit that the reasonableness test should not be applied with the proportional test, as the proportional test is stronger on its own, and given the fact that these rights are very, very strongly protected rights, we submit that the proportional test should be used solely as opposed to in combination with the 2He standard.
Thank you very much. Right. Who's for the respondent?
May it please the Court. May it please the Court. My name is Patricia Brannick, and with my co-counsel, John Cunningham and Christina Hynes, we are appearing on behalf of the respondents, Ireland and the Attorney-General. Section 7A of the Criminal Law Sexual Offences Act 1993, inserted as Section 25 in the Criminal Law Sexual Offences Act 2017, which is located in the Book of Authorities under legislation at tabs 1 and 3. It provides that the purchase of sex is a criminal offence. Our clients are defending the constitutionality of Section 7A of the Act. It is respectfully submitted that the High Court ruling of Mr. Justice McGlenn was correct. We will be presenting 4 submissions in this case. The presumption of constitutionality, and in particular the strength of the presumption. There was no unwarranted infringement of the right to privacy. The equality rights of the applicant has not been breached, and the provisions of the section are proportionate. All legislation enacted under the 1937 Constitution enjoys a presumption of constitutionality, and the burden of proving otherwise rests with the person alleging the unconstitutionality. The Court will recall that the rule itself has not been challenged by the applicant. May I open the Irish Supreme Court case of Ryan and the Attorney-General, decided in 1965.
Yes, fire away. Thank you, Ms.
Does the Court wish to be appraised of the facts of the case?
No, I'm well familiar. Thank you.
In the Ryan case, located under Irish cases in the Book of Authorities at tab 24, it was held that the presumption of constitutionality operates at a heightened level where the exercise of personal rights may be in conflict with the common good. Mr. Justice Kenny held that the presumption applies with particular force to this type of legislation. The heightened strength of the presumption in cases involving challenges to legislation concerning personal rights implies that judicial deference should apply. May I open the Irish Supreme Court case of Norris and the Attorney-General, decided in 1984? Thank you. Does the Court wish to be appraised of the facts of the case?
No, you can open the matter. Thank you.
In the Norris case, located under Irish cases at tab 19 in the Book of Authorities, the Court held that the right to privacy, or the right to be left alone, can never be absolute, and the Oireachtas can legislate for the common good and in the best interests of society as a whole. I submit that the applicant's right to personal privacy in accessing prostitution with no penalty must be refused by the Court, and the Court should find in favour of the respondents. If there are no questions, that concludes my submission, and I shall hand over to Mr. John Cunningham, who will present on equality rights.
Thank you very much. Ms. Brannick.
If it please the Court, I'll be arguing on equality. Section 7A of the Criminal Law Sexual Offences Act 1993, as inserted by Sections 25 of the Criminal Law Sexual Offences Act 2017, criminalises the purchaser for the payment for sexual intercourse. Mr. Greene freely admits that he did pay Miss Wilberforce Smith for sexual intercourse. This is a gender-neutral offence. The Act criminalises the purchaser, whatever gender the purchaser may be. So there is no discrimination in the wording or the execution of the Act. Article 40.1 of the Constitution states, "All citizens shall, as human persons, be treated equally before the law." It further states, "This shall not be held to mean that the state shall not, in its enactments, have due regard to differences of capacity, moral and physical and social function." If it please the Court, I'd like to introduce MD, the Irish Supreme Court case of MD, a minor, and Ireland, decided in 2012.
Thank you very much. No need to open the factual backdrop. It's been cited already, thanks.
Would you like to be...
No need to do that.
Okay. It's on tab 16 in the Book of Authorities, Judge, and I'm going to paragraph 39 and 40 initially. And in the Right Honourable Chief Justice Ms Susan Denham prescribes in this that the general principle that citizens are to be held equal before the law is in Article 40.1, which says equality is not in all cases an easy principle to apply in concrete situations. People may be equal in some respects and not in others. The strict equality is the norm that laid down by Article 40.1. However, the article recognises that perfectly equal treatment is not always achievable. Rather, the article recognises that applying the same treatment to all human persons is not always desirable because it could lead to indirect inequality because of the different circumstances in which people find themselves. She continues, and she quotes, "The framing of sexual offences in such a way as to protect young people from the dangers of early sexual activity is a matter of notorious difficulty." And she then goes on to cite from the United States Supreme Court case of Michael M. versus the Superior Court of Sonoma County, and Judge Rehnquist, who said that the Equal Protection Clause did not demand that a statute necessarily apply equally to all persons or require things which are different in fact to be treated as law as though they were the same. Ms Denham continues with the Section 5 of the Sexual Offences Act 2006 and says that the state justified the legislation by a social policy of protecting young girls from pregnancy by creating a law governing antisocial behaviour, for example, underage sexual intercourse. This was a choice of the Oireachtas. Even at a time of social change, it is a policy within the power of the legislature. The Act, as set out earlier, makes both sexes liable for breaches of the offences created. However, Section 5 excludes the girl from criminal liability when the offence is sexual intercourse, but not for other sexual acts. The rationale behind this is that only females can get pregnant, and the Oireachtas has legislated to protect females from being vulnerable. While Miss Wilberforce Smith is not a person trafficked for sexual purposes or held against her will and forced into prostitution, Miss Wilberforce Smith is neither alcohol, drug or substance dependent, nor is she destitute. Miss Wilberforce Smith does not fit the profile of the average prostitute. She is essentially an independent contractor.
Just on that, just going back, Mr. Cunningham, can I ask you, you place a great store, obviously, on the submission and on the fact that the statute and the provision is gender neutral.
Yes, Judge.
So do I take it that if it was Mrs. Greene going down to the Galway races and met Mr. Wilberforce Smith, who was over from the UK with the same objective as Miss and from the same background, but I just make that observation because you also rely on what the learned Chief Justice at the time, Denham CJ has said in MD. In MD, obviously there was a distinction because certain acts of the girl weren't of criminal nature, weren't deemed to be, as I understand it. Why are you trying to persuade me that MD is effectively a case that I should take particular cognizance of?
Well, Judge, the young girl in MD could have ended up pregnant. And as I'm about to say further down here, that young girls who get pregnant at a young age can have health issues as a result of it, psychological issues, but there's also the inherent risks and social damage of being a teenage parent and trying to raise a child. So that the Oireachtas are legislating to protect young females in this position.
I understand that, and that was the reason, the rationale for the decision at MD. But how do you say that assists you in this case, where you have effectively adults, and bearing in mind that the situation that the Act provides, that the situation could have been the reverse, where, as I said, it was Mrs. Grainne and Mr. Wilberforce-Smith.
Well, as I was saying, Miss Wilberforce-Smith is an exception to the rule of prostitutes. She doesn't fit the stereotypical image or the reality. Many prostitutes are at the fringes of society and they're very vulnerable persons. Miss Wilberforce-Smith was fortunate enough to be educated and articulate and able to operate as an independent contractor. She's not under the control of a pimp or a madame in a brothel. So she's operating as a sole trader. I
see. Thanks very much. Continue. Apologies for my interruption of your submission, Mr. Cunningham.
As I was saying, the vast majority of prostitutes are vulnerable persons and may have addictions to alcohol, drugs and other substances. The majority of prostitutes are impoverished and many are forced into prostitution. These prostitutes are the people that are protected by Article 40.1 and the Criminal Law Sexual Offences Act 1993 as amended. The state does not legislate for individuals, but rather legislates for the common good. Females are more vulnerable in sexual offences, and the state recognises this. For example, in rape and statutory rape cases in particular, a female carries the risk of pregnancy and the health risks associated with teenage pregnancy and the social disadvantages that can accompany being a teenage parent. That is why the state protects the young female through legislation, which also acts as a deterrent to older males who may often themselves be teenagers. The statute is designed to act as a deterrent to the purchasers of sexual intercourse and is designed to protect vulnerable women who are forced to work as prostitutes. There is no breach of Article 40.1 in this instance, nor is Mr. Greene being discriminated against by Section 7A of the Criminal Law Sexual Offences Act 1993, inserted by Sections 25 of the Criminal Law Sexual Offences Act 2017. If I can be of no further assistance to the Court.
Thanks very much.
This completes my argument on behalf of the respondent, and I now hand you over to my co-counsel, Christina Hynes, who will present the argument on proportionality.
Thank you.
Thank you.
May it please the Court, I would like to move on to our final submission. Any invasion of a constitutional right must be proportionate to the objective that is trying to be achieved. It is an attempt to strike a balance between the restrictive measure imposed by the corrective measure and the severity of the nature of the prohibited act. In this instance, I will be arguing that the measures imposed are proportionate to the sentence given. May it please the Court, I would like to introduce the Irish Supreme Court case of Cox and Ireland, decided in 1992, that can be found on tab 3 of the Book of Authorities. Would the Court like to remind you of the facts of the case?
No, I know the facts.
Thank you, Judge. The Supreme Court found the legislation in this instance to be disproportionate as the only goal achieved was deterrence, and such a harsh penalty was not proportional to the only goal being achieved. It introduced the concept of reviewing legislation on the basis that it goes too far in enforcing legitimate purpose. A main objection of the legislation in question is protection. It is set out to protect prostitutes and recognise the issue of sexual violence and the unsafe working conditions that prostitutes face. With that in mind, the castigation in this instance is proportional to the objective. May it please the Court, I would like to open the Irish Supreme Court case of Heneghan in Ireland, decided in 1994, found on tab 10 of the Book of Authorities. Would the Court like to be reminded of the facts of the case?
That's fine. You can open your...
Thank you, Judge. On page 607 of this case, it set out that the object of a provision in question must be rationally connected to the objective and not be arbitrary, unfair, or based on irrational consideration. It must impair the right as little as possible and be such that the effects on rights are proportionate to the objective. It is respectfully submitted that this piece of legislation passes this test on all fronts. The object is to deter people from soliciting prostitutes, and it recognises the reality that prostitution is an issue and protects people working in the industry regardless of why they are there or their background. May it please the Court, I would like to open the Irish Supreme Court case of Toohey and Courtney, decided in 1994, that can be found on tab 30 of the Book of Authority.
Yes.
Would the Court like to be reminded of the facts of the case?
Briefly.
In this case, the plaintiff sued the defendant, who was a former solicitor, for acting negligently. The plaintiff was statute barred by Section 11 of the Statute of Limitations and challenged the constitutionality of this. Mr. Chief Justice Finlay upheld the constitutionality of this section as it did not actually infringe on the plaintiff's right to litigation. Mr. Chief Justice Finlay outlined, which can be found on page 47 of the case, that when applying the proportionality test, one must consider whether the balance contained in the impugned legislation is so contrary to reason and fairness as to constitute an unjust attack on an individual's constitutional rights. The infringements on the rights of privacy and equality are proportional to the objective of deterring the solicitation of sex workers and ensuring a safe working environment for them. It is in the public interest to protect prostitutes from violence, which, although it is recognised that it isn't an issue in this case, it has to be considered by the Oireachtas when enacting legislation. The restrictions imposed on Mr. Greene are not too excessive or unfair, and they are proportional in their objectives of deterrence and protection. If I can be of no further assistance, Judge, that concludes our submission, as set out by my counsel, Ms. Patricia Brannick and Mr. John Cunningham, on the issues of the presumption of constitutionality, privacy, equality, and the principle of proportionality. It is respectfully submitted that the learned High Court judge was correct in his judgment, and we respectfully request the Court to reject this appeal. Thank you, Judge, if you have no further questions.
Just one or two matters. Your colleague, Mr. Cunningham, obviously emphasised the provisions of Section 7A as a deterrent, and you've argued on as to the proportionality. Now, I note you've quoted Toohey and Courtney, where defined it to be disproportionate. It has to be so contrary to reason and fairness. I think those were the words.
Yeah.
The learned judge, and the appellants have contended for that a slightly different approach to proportionality, that effectively somehow reasonableness should be, or reason should be, not applied. Have you any observations on that? You heard your colleague and they argue that in response to me on the other side.
As my learned colleague said, that perhaps the issue of reasonableness shouldn't be applied, but I think it should. The standard should be a reasonable one. And in this instance, I think it is reasonable to infringe on a person's rights for committing a criminal offence, which Mr. Greene completely and utterly admits he committed. He says he committed the offence and he owns up to that. And the fact that he feels that his rights are being infringed upon due to his own complete and utter consent to commit into a crime, I think is a reasonable standard that should be considered by the court.
I see. Thank you, Ms. Hynes.
Thank you for your time, Judge.
Reply? Yes.
We will just make a few points on our rebuttal. The prostitute in this case is not a vulnerable female, nor are all prostitutes in the profession female or vulnerable. The act between the appellant and Miss Wilberforce-Smith was consensual with no harm. This act can be compared to Mr. Greene giving Miss Wilberforce-Smith money to go to the mall with him. The act is between consensual adults with no harm involved. We'd make particular note that trafficked people are already protected under Section 5.2 of the Criminal Law Human Trafficking Act 2008, and therefore the issue is not pressing as these people's rights are already protected. We are also arguing that discrimination is against one party when two consenting adults, partook in the act of prostitution. So the criminalisation should not be on just one person, it should be on both of them if the aim of the objective of the legislation is to stop prostitution. We are also arguing, sorry, that concludes our arguments.
Just one of it occurs to me, Ms. Wolfe, the one of the matters that you've impressed on the court more than once, if I is the, as I understand it, and correct me if I've mistakenly taken up your point, that if Mr. Greene had paid Mr. Wilberforce-Smith to go to the mall with him, that he'd have been subject to penalties. That, as I understand.
We're saying he shouldn't have been, that right shouldn't, he should be allowed to do what he wants consensually with another person when there's no harm involved, as was the situation in this case and in the mall situation. The state should not interfere with his right to privacy. It should be the right to be left alone, essentially, Your Honour.
But obviously in this case, I mean, if the porter had observed, the hotel porter or whoever it was, had simply observed Miss Wilberforce-Smith outside the hotel and meeting Mr. Greene and seeing them going into the Galway shopping centre, and if it were, obviously it would be a matter of to be established at the trial, at the criminal trial, if it were he to be prosecuted based on what the porter said, whether or not anything of an untoward nature took place there. But simply, if he paid Mrs. Wilberforce-Smith to Cunningham to the races, for example, presumably no prosecution would ever have arisen, unless it could be established there was some factual basis for an act of a sexual nature having taken place.
Exactly.
Yes. But what are you, I just want to tease out with you, what are you saying, why do you use the mall analogy?
We use the analogy because we're emphasizing the fact that there is no harm involved in this act that was done in private between two consenting adults. It doesn't matter what they were doing. It shouldn't matter what they were doing because they were doing it consensually in private. So that's the point we really emphasize.
Thanks very much, Ms. Wolfe. Yes, Ms. Hynes.
It is respectfully submitted that although in this case the issue of vulnerability does not arise, the Oireachtas cannot legislate for the individual, and that the infringements on the rights of Mr. Greene are minimal. He is only subject to a Class E fine not exceeding €500 and a criminal conviction, which, considering that Mr. Greene broke the law and freely admits to breaking the law, seems fair and reasonable. On the issue that is it a private matter between two consenting adults, of course, that should not be an issue brought before the courts, but when it's a matter involving a criminal offence, it should. And especially when you consider that on the issue of the discrimination of one party, when two people are involved in the act in question, there are many cases, offences in front of the law where there's two people involved in the act and only one is liable, for example, in the instance of murder. And finally, the legislation the aim is to protect prostitutes and to stop prostitution. And it does that by giving a higher legal status to the prostitutes to make it safer. If something does happen to them, they can go to authorities and have that issue addressed. And also, it, by extension, can allow them to actually escape the industry when they know they won't be prosecuted if they've been acting as a prostitute, whether it be against their will or not. Thank you, Judge.
Thank you. Just one small matter. As I you rely and say that it is a private in response to the contentions made by the other side. You emphasise, in response to their saying it is a private matter, you say it's a criminal. But isn't that the nub of the thing? Because Mr. Greene's argument is it shouldn't be criminalised at all, by virtue of the fact that it's private. So it's a circular thing, if you like. We have to ask which comes first, the privacy or the...
Well,
if you get my drift.
Yeah, I do, I think. The issue is that his privacy has been infringed on in that he did engage in a consensual act with a woman for remuneration, and a porter saw him and reported him. If, as the point was made earlier, if he went into a mall, the same report might not be made. However, the fact that it was, albeit a consensual act, in exchange for payment makes it okay for the right to be infringed, because it's reasonable for the greater good, for public. It's in public interest not to allow prostitution to just occur in our society. If that answers your question, George. Thank you.
All right.
Well, again, on both sides, most excellent presentation. I was just inside thinking to myself, if this were being argued in the Supreme Court with a 7-judge division, I suspect it might be a 4-3. That's the best way I think I can describe the quality of the presentations and the level of advocacy and the strength of the various arguments that were made before the court. Of course, I'm in there and fighting with my shadow effectively, so I have had to make the call. But again, I just want to say there was no more than a whisper in it, because I thought both were excellent. I thought the responses on your feet to questions, incoherent as they were on occasions, were excellent and showed that the great ability on all sides to think on their feet, which is really the hallmark, I think, of a lawyer, particularly one who wishes to litigate in the courts, because very often cases can be, won't say it will always happen, but on occasions where you can make the argument as forcefully, you may well be a persuaded judge who is maybe hanging on the brink about which way to go, and it may well be the force of the argument and the strength with which you advocate the cases you rely on, and indeed how on occasions how some can be distinguished. And that was done, if I say again, on both sides with distinction. But obviously, as in all these things, and when they say this, whether they say it in this sort of competition or indeed if it's Strictly Come Dancing or something like that, there can ultimately be one winner, but there is just a whisker in it. But in all the circumstances, doing the best I can, having regard to all of the submissions, written and oral, and the nature of the manner in which the matters were put forward, I'm giving it to Team 3. Thank you very much.